Okay, we're going to go ahead and start with negligence and strict liability. Maybe we can get out of here in a decent hour.
Please.
Please. For the record, that was Jesse. Okay, negligence, there has to be foreseeable risk. Now, what is foreseeable risk? Well, we talked about reasonable before. Foreseeable risk means we all ought to be able to figure out that it might just happen. The definition of negligence is the failure to do what a reasonable person would do under the same or similar circumstances. The failure to satisfy a reasonable person's standard of care. So if all of us say, yeah, it's reasonable for us to jump off the roof of this building, then a reasonable person would be okay to do what we are doing, which is jump off the third floor of this building. On the other hand, if we said, no, that's not reasonable, that would be a high risk activity, then it would not be reasonable and would not satisfy the reasonable person's standard of care. Okay? So negligence says that if we don't do what reasonable people would do under the same or similar circumstances, the failure to satisfy a reasonable person of standard of care is not satisfied, and we are negligent. The elements of negligence are four. First, it has to be some duty. We have to have a duty, the standard of care consistent with the actions of a reasonable person that defendant owes plaintiff. Two, a breach of duty. The defendant fails to satisfy the reasonable person's standard of care. Thirdly, there has to be some causation. The defendant has to do something that causes plaintiff's harm. That amounts to a breach of duty, which is a failure to satisfy the reasonable person's standard of care. And finally, there have to be some sort of compensable damages. So, a duty. We have to stay at least 2 car lengths behind the car in front of us so that our brakes work right and we can stop in time at a stop sign. We breach that duty by traveling right on somebody's bumper, which I always seem to have people traveling on my bumper because I obey the speed limit and they just don't like it. Causation. Defendant's conduct amounts to a breach of duty. The guy that was riding my bumper slammed into the back of my car. And it caused me harm. My poor little car was hurt. And then damages. I had some sort of compensable damages. They have to pay for my car to be fixed. I go to the doctor, find out I have to have a brace on my neck. I have to miss work for 6 weeks. You don't get to come to class and listen to me at all for 6 whole weeks. That would be horrible for you. Yeah, just awful. There's some special things that we can apply when we apply negligence. The first are standards and doctrines, then res ipsa loquitur, negligence per se, and danger invites rescue. And we'll go through those one at a time, but not trying to take too long. Res ipsa loquitur means the thing speaks for itself. If you come up to the edge of a cliff and there's a fence up on that cliff, should you climb over that fence to look down to see what's below in the valley below? No. That fence speaks for itself. It's meant to keep you from doing that. Do people do that anyway? So they are negligent. Res ipsa cases require the following proof. The event was the kind that ordinarily does not occur in the absence of negligence. In other words, if there was no negligence, I wouldn't have climbed over the fence. Other responsible causes include the conduct of third parties, and plaintiffs have been effectively ruled out. Somebody didn't push me over the fence. indicated negligence was within the scope of the defendant's duty to plaintiff. I wasn't supposed to climb over there. It was my duty not to climb over the fence. And if there's somebody with me, it's my duty not to take them with me. Remember that. If you ever fall off the edge of a cliff, don't grab the person next to you and make them go with you, or it's your negligence. It's res ipsa loquitur.
Only if they survive, though, right?
No.
Oh, their family's going to get you. Oh, their family's
I'm
going
not
to
trying
get
to
you.
die alone, sorry.
In order for there to be risk, and every negligence has to have some sort of risk associated with it, we have to have causation in fact, which is actual cause, and proximate cause, which is foreseeable cause. They don't have to be the same thing. You don't have to have them both. If you have actual cause, you automatically have foreseeable cause, but you don't have to have actual cause to have foreseeable cause. For example.
Yeah, I was about to say that.
For example, I'm sitting in a parking lot of a mall, and there's a big field full of dry grass. And I have a cigarette. And I put the cigarette out on the ground, and I think it's out. And I flick it into the tall grass. I get in my car and leave.
So you put it out on the ground, but you still pick it back up?
Yeah, because I don't want anybody to accuse me of littering.
But you just don't.
Right, you just go in the grass.
And I flicked it over into the grass. This is just an example. We let me finish. I flick it into the grass, and the grass catches fire. So, my cigarette butt was the actual cause of that fire, wasn't it? Was it foreseeable that that would happen?
No, because you got
Well, it could be foreseeable because you know that could have been caused by a cigarette.
Yes, that's exactly right, Shree. I knew that if there was some chance that that cigarette was still hot, it could catch that dry grass on fire. So that was foreseeable, even if I didn't think about it. It was foreseeable, but it was also actual. Now, so the fire burns. And it burns over to this dirt road, and it goes out. Fire trucks don't have to come or anything. It just stops. And then it starts to rain and thunder. And there's lightning. And the lightning on the other side of the road catches the grass on that side on fire. Am I responsible?
No.
Was I responsible for the grass on the other side for my cigarette? Yeah. Was I responsible for the lightning? No. That is what we call a break in the chain of causation. Causation has to happen one thing right after another in order to put one person with one result. If something comes in the middle that stops that, we have a break in the chain of causation. And I'm no longer responsible. Okay? So, that's causation in fact and proximate or foreseeable cause and the difference there. Actual cause, or cause in fact, is when the defendant's breach of duty results directly in plaintiff's injury. That can include injury to property. But for is a test that we use here. But for defendant's breach of duty, plaintiff would not have been injured. Proximate cause, or legal cause, the plaintiff and the plaintiff's damages were reasonably foreseeable when defendant breached his duty to the plaintiff. So proximate cause, things have to be legally foreseeable or reasonably foreseeable. For example, I go into a party. I park my car. I don't turn the wheels in toward the curb. And I'm parked on top of a hill because the house is at the top of the hill. I put my car in park, but I don't set the foot brake, parking brake. While I'm in there, somebody comes up from the back and taps my car. It doesn't go anywhere. It just sits there. 2 hours later, it starts rolling down the hill. Now, is that my fault?
No, it's the person who has the car fault
But
because
it is
they.
yours because you don't
I didn't set the emergency brake, and I didn't turn the wheels in the way you're supposed to. But that tap just popped it out of park. Otherwise, but for the fact that I had not done what I was supposed to do, that car would never have moved. Right? So, my car goes down the hill, goes through a fence, hits a farmer's barn, goes into the farmer's barn, knocks over a can of diesel fuel. The hot engine sets the diesel fuel on fire, burns the barn down. Who is responsible for burning that barn down? I am, because it's proximate, it's reasonable, it's foreseeable, and it's actual cause. I'm responsible for that. Yes, it is. Guess what? That actually happened.
To you?
Not to me.
I'm just saying you always went through something crazy.
No, it didn't happen to me. It didn't happen to me. But it did happen in Ohio, out in the outskirts of Akron, where my wife was born and raised. It actually happened out there. I thought it was hilarious until they told me there was dynamite in the building right next to the barn that burned down. And I didn't think it was so crazy after that. I was glad we got away. In negligence, when we have a tort that involves it, the person committing the tort neither wants to bring about the consequences nor believes they'll occur. It's an accident. It is an accident. For negligence, there has to be risk, and the risk has to be foreseeable. Okay? The elements of negligence are the defendant owes a duty of care to the plaintiff, defendant breached the duty, the plaintiff suffered a legally recognizable injury, and the defendant's breach caused the plaintiff's injury. So you have to be able to string all of those chain things together.
Heading, yeah.
Defenses to negligence, again, we have assumption of the risk. That is, if you know something's bad, why are you doing it? If you know that football's bad for your head, why do you go out and smack your head against other players' heads? Because it's fun. But it's also fun. But every time we go out there, we assume the risk of that, of getting injured. I talked about superseding intervening cause, where the road came in between the dry grass I set on fire and the dry grass that the lightning set on fire. The superseding intervening cause is always something that breaks that chain of causation between me and the final result. Contributory negligence used to be a complete defense at common law. That means if somebody else contributed to their own negligence in this accident, and they did something, in other words, the person who tapped my car and popped it out of park, regardless of what I did, they could cause me to be completely defended from that because they contributed to all that devastation down at the bottom of the hill. And that's what it was called, contributory negligence. They contributed to it. So that devastation wasn't my fault anymore. And I could use that as a theory to try and get off. You have a question?
So, if you did use that, it worked? Like,
It used to. It used to, but they've legislated it out of existence now. I mean, people still try and use it, but they just haven't read the statutes. Because the statutes no longer have eliminated contributory negligence as a defense. Comparative negligence is more common. You've heard probably when a suit is over and the jury makes a decision, they say, well, we're awarding, they ask for $1 million. And they say, we'll award $400,000 to this party and $600,000 to that party. Well, that means that the party that won the 400,000 was 60% negligent because they were responsible for what the other award was, and this other person here was 40% negligent, and they got the 60,000. So comparative negligence is how we break up awards. If I am 50% negligent and another person is 50% negligent, then I only have to pay half of the award. The other person, who's my co-defendant, has to pay the other half. 50-50. So that's what is used these days in place of contributory negligence. Okay? Make sense? And you'll see that even on some of these TV shows that talk about this sort of thing. They say, well, we find the defendant 70% negligent. Well, that means the defendant pays 70% of whatever the plaintiff is asked for. That means the plaintiff must be 30% responsible for their own negligence. Defenses, contributory negligence, there we go, allows the defendant to completely avoid liability by showing that the plaintiff's negligence, even to the slightest degree, contributed to the plaintiff's harm. Comparative negligence allows apportionment of liability between the plaintiff and the defendant according to the degree of responsibility each bears for plaintiff's harm. And assumption of the risk allows the defendant to completely avoid liability by showing the plaintiff actively, voluntarily, and willingly engaged in an activity where the harm was foreseeable. In other words, I decided that I would go rock climbing. I assumed the risk of going rock climbing. So if I were hurt rock climbing, it's my own fault. The duty of professionals and the duty to rescue. Okay. A lot of people like to know about these things. Professionals are held to a standard appropriate to their profession. Ordinary persons have no common law duty to rescue or warn. However, there may be good Samaritan statutes. What does that mean? Okay. Let's start at the bottom. I'm an ordinary person, and I come upon a traffic accident that just occurred. I get out of my car, I go running over, I look down at the people and say, "You're injured." I don't have any duty to do anything. That ordinary people who are not medically trained in any way have no duty to try and do anything except call 911 and keep them from hurting themselves any further. Okay. Let me keep going because it may answer your question. So, I'm a Boy Scout leader. Okay, so break my concentration, will you? Okay, so I'm a Boy Scout leader. I am trained in first aid. I see the people who are injured. My duty as a Boy Scout leader who has been trained in first aid, and I actually carry a first aid card in my wallet, is to go over and assist them with the extent of my basic first aid training. In other words, if they have wounds that are open, I try and stop the bleeding. If they are in cardiac arrest, I can try and apply CPR, but you have to be certified. I have a duty to apply first aid and CPR if I come upon an accident or someone who needs that, and call 911 because I am first aid trained, but that's all I should do. I should try very hard not to injure them any further. okay? And if there's something that's beyond my ability to help with, I try just to make them comfortable until the EMTs arrive, okay? So the next level is, there is an off-duty EMT who is from the same county, and he pulls up in his car, he opens his trunk and pulls out his bag. He runs over and says, "Have you called 911?" I say, "Yes, they're on their way. I'm on the phone with them now." He says, "Tell them that badge number so-and-so from this county is on scene and will attempt to apply rescue methodologies." So he applies his skills further, which are beyond mine, to take care of these people, because he's an EMT, and he would be one of the ones that would take care of them anyway. So, the next person that pulls up and runs over is a nurse. The nurse comes over and helps the EMT, but she can do no more than what the EMT tells her to do. Even though she may be highly trained, it's the EMT on site who is in control of the accident site. And then all of a sudden, pulling up in his big old limousine is Dr. Frist. He used to be a senator. You know Dr. Frist? You know who he is? He used to be a senator in Washington. He's from Middle Tennessee. He pulls up. He gets out. He gets his bag. He runs over. He's got his white coat on and his stethoscope. He runs over and says, "Do you need assistance?" And the EMT says, "Yes, I need this, this, and this." He will only do what the EMT tells him to do, because the EMTs are the one in control of the accident scene. Then the ambulance pulls up with additional EMTs and rescue people, and they will triage and assess the injuries and apply from there, and everybody else backs off. Okay? That's the way it runs. So, professionals only have a standard appropriate to their profession. Ordinary persons have no common law duty to rescue. Good Samaritan statutes might exist. Now, Jillian, your question.
Okay, so I believe like maybe a year or two ago, it was like on everybody. A lady or something was either like sick or to labor, I can't remember. But there was a doctor on here, but they didn't want to come here because it was like a race issue. So what happened there?
Nothing.
Nothing?
Nothing. Sorry.
I just wondered.
Yeah, Jess.
What happens if they end up doing harm? Like say the EMT hadn't showed up, it was just the nurse there and she tried to help and ended up doing harm.
That's exactly what I was going to talk about next. This is called a Good Samaritan statute. Most states have a Good Samaritan statute in place, which says, if someone tries to assist and is unable to assist, and the person is either further injured or dies during the attempt to help them and keep them safe, the individual who is attempting to help, if no other help is available, is absolved from all harm. We had, in fact, they have international laws like that too. Germany, when I was in Germany, stationed with the military, I saw an accident. You're going to think I made this one up again. There's this little car called a Citroen. And the Citroen is a car, it looks like it was made by a tuna fish can company. Because it's about this wide, and it has a steering wheel in the center, and there's a passenger in the back. It's got a motorcycle engine, and it's run by a chain drive. And it's got this canvas opening on the top. And we saw this thing, it was racing down the road real fast, and it flew off a curve on the road and went into this newly plowed, fortunately, field, and it flipped over. So we get out of the car, in fact, a whole bunch of us get out of the car that had seen this, and we're running over with our first aid kits, and we're setting out our warning triangles and all that sort of thing. The guys crawl out of the top of the car, pick up the car, take it back up on the road, put it on the road, and drive away. And the rest of us are standing there like, what just happened? But there was a duty for us to stop, because that's what the German Good Samaritan statute said we had to do. And then we all said, where were they? Is there a guest house around here? We can go have a beer? And one of the guys said, yes, it's over there. I said, let's go. And we all went over and met some really nice people that night. It was great. Okay, so that's what Good Samaritan statutes will do. They introduce you to lots of wonderful people. Damages for negligence, well, you have your standard compensatory. You can have punitive. You have court and attorney fees, and you have incidental damages. Now, you know what court and attorney fees are, but you remember what we talked about incidental damages as? Things like travel and postage, and if somebody ruins their suit or needs to have something dry cleaned, you can, while they're in court, they can have all those damages put together into one package and included in the lawsuit. That's what an incidental damage is. So, we just explained that, we know those. So, strict liability. This is not my kitty. My kitty was much smaller than that. When is strict liability invoked most? When some product has a design flaw. Sometimes products will have a design flaw. There was a case in Ohio where a basket, which was being used as a bassinet for a newborn baby, had a coating on it that actually ended up suffocating the child because the vapors were so heavy coming off the basket. That was held to be a design flaw because the coating was not adequate for its intended purpose, and the manufacturer of the coating was sued and had to pay damages for that. With inherently dangerous animals like exotics, kitty up here, those made dangerous by law, like dangerous dogs, and those known to the owner to have excitable tendencies that could cause an injury even without biting, like jumping up and knocking someone down. You're going to think I made this one up again. There were two neighbors, and one of the neighbor ladies had this really nice Pekingese. And the neighbor lady next door used to love to come over and see the Pekingese and play with them, and they'd have tea in the afternoon and all that sort of thing. Play cards. And the Pekingese generally was not a problem. But one day, she came over to the door. Before she could be recognized by the dog, she came inside the door, and the dog got so excited and so happy, started jumping up and down, it knocked her over and down the stairs, which were right there at the door.
Is she alive?
Yeah, she lived. She was alive enough to sue.
I would have killed her.
I mean, she knew that.
No, the dog. You know, this was an excitable dog.
Now, she knew they had a dog.
But that's a little dog though, so how
That's
do
her
I
fault.
So some dogs
She
have a
did not
really
know.
good
She
vertical
was not
leap.
the president. She just walked right
So
up.
the dog jumped up and down and knocked her down, and that is why I put this one on here, because it can happen that way. But there must be a duty imposed by law for this one with inherently dangerous animals. Otherwise, it would be just simple negligence. So it's not strict liability. With strict liability, all they had to prove was that the Pekingese knocked her down the steps. If there was no law that said that kind of thing in the state was a problem, then it would be simple negligence, and it wouldn't have been quite as damaging as it was for either party. I hope they managed to repair their friendship. Government immunity from torts. I fought this in the United States Supreme Court. There was a case that originated from an appeal in the 11th Circuit in St. Louis from a government construction job in which something the government did caused a worker to be badly injured. And we sued the federal government and said that they should allow this because the individual otherwise would not have been injured. It was the government's fault. We went all the way to the United States Supreme Court with it, and I was one of the ones that argued this. But the Supreme Court held that under the 11th Amendment to the U.S. Constitution, the federal government cannot be sued for its own tortious conduct unless an existing statute or new law specifically allowed the suit, and the government had not said it was okay to sue them. And so it was thrown out, and the individual had to seek compensation elsewhere from his own insurance company. I still think we were right on that one. I still think we're right. I still think the government should be liable for its own tortious conduct. But I lost. So that's all I can say. We're done for tonight.